welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, the state of Ohio is asking the Vinton County judge that's in charge of this case against the Sider family to reject Elizabeth Sider's request to drastically reduce her bond. They are arguing that she presents a flight risk and that she faces serious felony allegations involving her 16 children and could soon face additional charges before the grand jury. That is the most recent state opposition that was filed this week on Monday, August 17th, in response to Mr. Stoley's motion seeking to modify his client Elizabeth Sider's existing $300,000 cash or surety bond to a recognizance bond. He wants to let her go out with a GPS monitor and the promise that she is going to appear in court because, well, she's got too much at stake and she wants to be back with her children. Yeah. So let's go through the current update on some of the court documents, and we're also going to go through the whole mental competence evaluation that was just ordered as well by the judge. Okay. So again, this is the Vinton County court website. I don't know if it's clerk. It looks like State of Ohio's website. And in this particular website, we've mentioned it before. I think you can reorder it, but theirs actually seems to go, when you initially pull it up, it goes from oldest to newest. So I can actually just flip it here, and it should flip. There we go. So it'll flip all the current documents to be at the top, because I don't know about you guys, but when I look at the information, I like the newest stuff to be on the top and then go to the bottom. So we're going to actually look at what was filed by her attorney on 8/4, since we haven't gone through that yet. It's a motion for evaluation to determine whether the defendant is not guilty by reason of insanity and whether the defendant is competent to stand trial. So that is definitely a big one, because is she competent to stand trial? Are any of these four defendants competent to stand trial? I mean, that really is the ultimate question, right? And that doesn't mean that they may not be competent now, but could they be competent in the near future? And that also doesn't mean that they wouldn't serve some sort of time, but they have to do these mental evaluations to see mentally, can they help defend themselves. So again, this was filed on August 4th. State of Ohio versus Elizabeth Siders. Motion for an evaluation to determine whether the defendant is not guilty by reason of insanity and whether the defendant is competent to stand trial. Now comes counsel for the defendant, who hereby respectfully moves the court for an order that a formal evaluation be conducted in order to determine whether the defendant is competent at this time to stand trial to the offenses as charged herein. Alternatively, if the defendant is found to be competent, counsel hereby simultaneously requests that the defendant undergo an evaluation to determine if she's not guilty by reason of insanity because she was suffering from a condition which would produce legal insanity at the time of the alleged offenses. Defense counsel makes this motion in good faith to determine defendant's mental condition at the time of the offenses charged and whether defendant is competent to stand trial on the offenses charged. The reasons for this motion are more fully explained in the attached memorandum in support, which should be incorporated herein. And here is the memorandum. Counsel was appointed by this court on July 2nd, 2026, to represent the defendant in the above captioned case. On June 30th, 2026, the defendant was charged in a criminal complaint. Thereafter, on July 1st, 2026, the state filed an amended complaint charging the defendant with 16 counts of child endangering in violation of ORC, State Statute 2919.22b1, and State Statute 2919.22e2d, each count being a felony of the second degree. The state The defendant appeared on July 1st, 2026 for an initial appearance hearing, at which time the bond was set at $300,000 cash or surety. As of the filing of this motion, the defendant has not been indicted, and therefore, counsel does not have all of the facts, evidence, or circumstances of this case or the defendant's subsequent arrest. However, in the interim, counsel has met with defendant on numerous occasions and for extended periods. During these interactions, counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense. Counsel is prepared to provide a more detailed accounting of his concerns and the specific conduct giving rise to these concerns directly to the court and eventually to the evaluating medical professionals. At this time, counsel believed that the defendant's significant mental health issues would not only affect whether she is competent to stand trial, but would also have affected her ability to understand the wrongfulness of her conduct at the time of the alleged offenses, such that the defendant would not have fully understood the consequences of her actions at the time of the alleged offenses, should such actions have actually constituted criminal conduct. You gotta love all the legalese, huh? The way they write these. Wherefore, counsel for the defendant respectfully requests that this court order a formal evaluation be conducted in order to determine both whether the defendant is competent at this time to stand trial to the offenses as charged herein, and if so, to further evaluate the defendant to determine whether she is not guilty by reason of insanity because she was legally insane at the time of the alleged offenses. Respectfully submitted. Again, we have John J. Thomas Stoley Law Offices. So, was she insane at the time of her offenses? Was she, was she insane? What do you guys think? Was she insane? Is her attorney, Mr. Stoley, is he right? I don't know. I'm kind of on the fence with Elizabeth. I think that she was a victim and didn't understand maybe certain things when she was younger. At the time of her initial pregnancy when she was 13, and then when she was basically forced to get married to Junior when she was 15. And then, of course, ever since then, she's been popping out the babies pretty much every single year. So, do I think that she is competent and able to, understand things and defend herself? I think she probably is, but, let me know what you guys think. Do you think that she's got mental problems? I mean, that's really that's really a good question. And that's what the prosecutor, is Archer. He's the one stating that, you know, she's fine as well as the others. I think that the only one that I have questions of are probably Gary Sr. He's the one that had the stroke. Remember, they let him out because of all his medical issues, because it was going to bankrupt, the county if they had to pay for his medical, care. And he is out with an ankle monitor. And, he's not going anywhere. He's an old dude and he can't move around very much. But Elizabeth, if she got out, or Gary Jr., they could get the heck out of Dodge pretty quick. I think that they could. And then on 810 is the actual order directing the evaluation. So let's check that out. So here is the actual official order. And this again was dated on August 10th of 2026. The order directing an evaluation to determine whether the defendant is not guilty by reason of insanity and whether the defendant is competent to stand trial. This matter comes on for consideration on the defendant's motion for an evaluation to determine whether the defendant is not guilty by reason of insanity and whether the defendant is competent to stand trial. This matter was brought before the court on August 4th, 2026. It is hereby ordered that 1. The Forensic Diagnostic Center of District 9, a certified forensic center designated by the Department of Mental Health, will examine defendant to determine whether defendant is not guilty by reason of insanity and whether the defendant is competent to stand trial. 2. The person conducting the examination will be an examiner as defined in Ohio Revised Code, State Statute 2945.37A2. 3. The examination date and time is to be scheduled with defense counsel and must be in person. 4. The examiner shall submit a written report of the examination to the court under seal no later than 30 days after the date of this order. This report shall be separate from the report on the issue of the mental condition of the defendant at the time of the offense charge. 5. The report of the examiner shall contain the findings of the examiner, the facts in reasonable detail on which the findings are based, and the opinion of the examiner as to whether defendant of capable of understanding the nature and objective of the proceedings against defendant and whether the defendant is capable of assisting in the defense of defendant. 6. If it is the opinion of the examiner that defendant is incapable of understanding the nature and objective of the proceedings against defendant or of assisting in the defense of defendant, the examiner also shall state in the report the opinion of the examiner as to the likelihood of defendant becoming capable of understanding the nature and objective to the proceedings against defendant and of assisting in the defense of defendant within 1 year if defendant is provided with a course of treatment. And they are referencing Ohio Revised Code, State Statute 294538C. 7. If it is the opinion of the examiner that the defendant is incapable of understanding the nature and objective of the proceedings against defendant or of assisting in the defense of defendant, the examiner also shall state in the report the opinion of the examiner as to whether defendant presently is mentally ill or has an intellectual disability and the recommendation of the examiner as to the least restrictive placement or commitment alternative, including consideration of needs and the availability of mental treatment in the community consistent with the treatment needs of defendant for restoration to competency and with the safety of the community. 8. The time at which defendant must be brought to trial is extended by virtue of Ohio Revised Code, State Statute 2945.72b, any period during which the accused is mentally incompetent to stand trial or during which his mental competence to stand trial is being determined. 9. The state of Ohio shall provide the examiner with a complete copy of discovery in this case within 10 days of the date of this order. And this was signed by the Honorable Judge Lena Featherhoff Rogers. Of course, it's copied to all these folks. So, in the next 30 days, she will be evaluated to see if, like it says in the order, if A, she is understanding her, right now, if she's capable of understanding what's going on, if she understood it at the time of these crimes, and also if she doesn't currently, if within a year, if she gets treatment, will she understand and be capable of facing trial at that time? So those are basically, I guess, the three that are really very important because they need to know, does Elizabeth Siders understand what she's being charged with? Does she understand that she's being charged with all these felonies, all these charges with her, involving her children, the fact that they didn't go to school, that they were living in squalor, all those charges that are against her. So I don't know. What do you guys think? Do you think that Elizabeth Siders is mentally competent? I'm curious what you guys think. I actually think that she's smarter than we think. Now, as far as I go back to when she was a teenager, kind of being, forced into this sort of world where she marries Gary Jr., starts popping out the kids. But, the education itself, she was allegedly taught by grandma. Okay. So she was the one, she went to school at home. So that doesn't mean that she doesn't have education. She just did not attend, you know, public schools, from that point going forward. I think that I think she's not a stupid person. I think she's pretty smart. And I know at least her brother Joey says she's pretty darn smart. But, the expert, we're going to have to rely on what this expert says once he or she conducts the evaluation. And the last thing that we have here is her attorney trying to get her bond reduced, modify her bond. Yeah. Yeah. So here is the state's memorandum to that. They filed this on the 17th, so that was just filed this week. So obviously, this is the most current update beyond the competency evaluation that the judge just signed the order for. State's memorandum contrary to defendant's motion to modify bond. Now comes the state of Ohio by and through the Vinton County Prosecutor's Office and presents its memorandum contra to defendant's motion to modify bond for the reasons expressed below. This court should deny the bond modification. Respectfully submitted, William Archer Jr., Vinton County Prosecuting Attorney. So yeah, we didn't go through their particular motion, but I can go back and grab that just out of curiosity to see what they mentioned. But this memorandum in support should kind of probably answer a lot of our questions. Again, memorandum in support. The defendant has filed for a bond modification in this case. This court should deny the bond modifications for several reasons. First, the defendant is facing multiple serious pending charges, multiple felony twos involving serious physical harm to her children, and thus is a flight risk and a potential risk to the victims in this case. Second, the defendant has filed a competency motion. Consequently, she is at personal risk until her competency is known. Third, the defendant has new serious felony charges that will be considered by the grand jury. Therefore, for the reasons expressed above, this court should deny defendant's motion to modify bond. Again, signed by William Archer Jr., Vinton County Prosecuting Attorney, and he certified that 2 days ago. That was Monday the 17th. I think it's should happen. I mean, like I said, not only does she have these serious charges pending, now they want the mental evaluation. So that alone, beyond the fact that she's a flight risk, she could go near her children when she doesn't, when she's not allowed. Because remember, she has been asking Mr. Stoley constantly. She wants to see her kids. She wants to see her kids. And guess what? They're not allowed to see those kids. Those kids are in safe place right now. They're all in safe places. So yeah. But then how do we know that she can take care of herself mentally? We don't know until this examiner does their examination. And I do think that there'll be new charges once the grand jury does meet. And I would think that they might be meeting very, very soon. We don't get knowledge on any of these cases when the grand jury actually meets, but I wouldn't be surprised if it's either by the end of this month or definitely in September, because I would think it would be very, very soon, especially if they've got the DNA results back. If that's what they're kind of alluding to, I think that there's a lot to look at when it comes to the DNA results. So let me see. Here is his filing here. Here's her attorney's actual filing on 7/8. Took a while for the state to respond to it, really. So this is this was her attorney's, Elizabeth Sider's attorney's actual actual motion to modify the bond, which he filed in July. Now comes the defendant by and through counsel and respectfully moves his honorable court to modify defendant's bond, currently set at $300,000 cash or surety, to a recognizance bond only, or in the alternative, set an expedited oral hearing on this motion. The reasons for granting this motion are set forth in the memorandum in support below. And here is what he had to say when he put out the motion. On July 1st, 2026, the state filed an amended complaint naming the defendant and alleging 16 counts of endangering children in violation of ORC State Statute 2919.22 B1 and E2D, all felonies of the second degree. On July 1st, 2026, the defendant appeared for her arraignment hearing and bond was set at $300,000 cash or surety. The Eighth Amendment to the United States Constitution reads that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Emphasis added. In Stack versus Boyle, the court found that the modern practice of requiring a bail bond serves as an additional assurance of the presence of an accused, and that bail set at a figure higher than an amount reasonably calculated to fulfill this purpose is excessive under the Eighth Amendment. Emphasis added. Similarly, State Statute 2937A of the Ohio Revised Code states that bail is security to ensure the appearance of an accused to appear in answer to a specific criminal or quasi-criminal charge in any court or before any magistrate at a specific time or any time to which a case may be continued and not depart without leave. In this case, the defendant is a 33-year-old mother with no known criminal history. Given the defendant's lack of a criminal history, she has never been charged with failure to appear before a court for a criminal proceeding. There has been no indication that the defendant has been anything but cooperative with law enforcement since the initiation of the case. As such, the defendant does not pose a significant flight risk. The defendant has indicated that they will provide the court every assurance necessary that she will appear to all future hearings and will comply with the terms set forth by this court. Should the defendant be released, she's going to wear a GPS monitor to check in with her assigned bond officer at whatever frequency this court deems appropriate, and to provide the court with a stable living address within Vinton County or a surrounding county. The defendant understands the charges alleged in the amended complaint are serious. However, the defendant has denied all allegations. The defendant has a vested interest in appearing for future hearings in an effort to clear her name. There's been no evidence provided by the state that the defendant is a risk to herself or the at-large community. Further, the children living in the defendant's home have been removed by the state, so there's no risk to any alleged victim of the charges the defendant faces. Through conversations with counsel, the defendant maintains that her principal desire to reunite with her children. She understands that reunification of any sort is an impossibility if she does not appear before this court. The defendant is indigent. The basis of the amended complaint was that the defendant was living in a home which exhibited extreme poverty. As such, while in many cases some bond may be necessary to ensure that the defendant appears as ordered, it seems clear that in this particular case, the defendant does not have the means to post any money as a bond, and they shall have been unable to post the current bond as it has been set. The language of ORC State Statute 2337.22a makes clear that bond is only necessary to ensure a defendant appears as ordered. Here, maintaining a recognizance bond should be sufficient to secure her appearance at all future hearings. Wherefore, the defendant, by and through the undersigned counsel, respectfully requests this honorable court to reduce the bond, currently set at $300,000, cash or surety, to a reconnaissance bond only, or in the alternative, set an expedited oral hearing on this motion, dated July 8th, 2026, signed J. Thomas Stoley, attorney for the defendant. Yeah. I think that it's gonna get denied, but I think she is a risk. I really, really do. And I mean, yeah, he's saying that she doesn't have a past. Um, she wants to be there because she's innocent, to clear her name and all these things. But really, beyond keeping her in custody, how does the state of Ohio have any sort of guarantee that Elizabeth Siders isn't just going to disappear into God knows where? I mean, really. So, my opinion is that she needs to stay behind bars, stay in jail, get the mental competency evaluation, see what comes of that. And that's going to be very soon. And I think most likely by the time that they get that that evaluation done, I think the grand jury will have met and brought charges. I mean, what do you guys think? I think that all four of these defendants are going to be charged significantly, And I mean, we already know Gary Siders Jr. has a ton of other stuff going on. I mean, his that's how they went to their house. His exposing himself, trying to be careful here on the YouTube streets, at the Burger King. That's sort of really did help these kids because it brought law enforcement to that door and it saved these 16 kids. And really, if let's say Elizabeth wants to claim, I'm a victim. I was initiated into this cult-like family when I was 15 and I've been, forced to continue to get pregnant, force out, babies, this, that, and the other thing. They helped you get out of that house. So I think she's living in a pretty decent situation compared to where they were. I mean, look at the house. It's on the screen. Look at the outside of that house. And we've seen some photos of the inside, but I mean, it's a trash hole. And I don't agree with her attorney either saying the whole poverty thing. I mean, we've talked about that too. Poverty does not equal slobbiness. It does not equal hoarding. It doesn't equal having crap all over your house, not cleaning up after yourselves, pee poop everywhere, all that. That does not, just because you're poor doesn't mean you're a slob. It doesn't mean that at all. So I don't think poverty has anything to do with the way they were living. I don't know what it was. Laziness, what? I mean, did she just not give a crap? I mean, but if she wanted to be a real mother, she would have made sure her children were living in much better conditions. I mean, she would have made sure that those kids were not having to live in this squalor of a home, and I put that in air quotation marks, and make sure that they had a happy life, and they did, and then they went to school, and they were well taken care of. So I don't think that she did nearly what she should have done as a mother. But again, let me know you guys' thoughts, obviously on the case in general, but specifically on Elizabeth. Do you think that we've been asking this from the beginning too, is Elizabeth a victim or is she just as much at fault as, Senior, Junior, and Christina? And also, is she mentally competent to understand the charges against her and defend herself in court? All right, guys, I hope you have a great rest of the day. And most of all, stay safe.